madam, who is the HOD of Department of Constitution, KIT School of Law, KIT University, Bhubaneswar. Madam, we welcome you on behalf of Hindi Vidya Prachar Samiti College of Law. We also welcome Dr. Rajendra Singh sir, our president, and Dr. Usha Mukundan madam, director of Hindi Vidya Prachar Samiti, and all my dear students, colleagues. So today we have gathered here on the discussion of topic that is creative interpretation by the judiciary on the article of 21 of the Indian Constitution. But obviously Kavile madam is there to elaborate everything on the theme of today's webinar. But little bit I can add.
I would request participants, please follow the instruction given in the chat box.
Thank you, sir. So Article 21, which possesses the transformative character of the Indian Constitution with the lots of its many interpretation, which today definitely we are going to learn from madam. And Indian judiciary has also attributed the wider connotations and meaning to Article 21 beyond the constitution makers' imaginations. So the judicial interpretation of Article 21 of the Indian Constitution and judicial activism on the part of the Supreme Court of India, judicial creativity and which justifies the role played by the Supreme Court of India in protection of the fundamental rights of the citizen. As we all know that Article 21 reads that no person shall be deprived of his life or personal liberty except according to the procedure established by the law. So many things which are taken into consideration by the Supreme Court under the Article 21, which is related to right to reputation, right to livelihood, right to shelter, right to social security and the protection of family, then right to health and medical care, pollution-free environment, pollution-free water and air, right to clean environment. So many rights are considered under this Article 21. So we are waiting eagerly, madam, for your thoughts on this Article 21. So over to you, Amar sir.
Thank you so much, ma'am, for throwing light on the Article 21, a very dynamic right, fundamental right of our Constitution of India. Now I would take an opportunity to introduce to you all our today's esteemed guest, Dr. Kaivalya Garikapati did her LLB from Montessori Mahila College of Law, Vijayawada in 1997. Madam has completed her LLM in Constitutional Law, Nagarjuna University. Madam has, she was a gold medalist in Acharya Nagarjuna University, Guntur. She cleared APSET in 2013. She completed her PhD at Acharya Nagarjuna University, Guntur in 2019. Madam had participated as an advocate. Madam has practiced as an advocate in Guntur Bar Association from 1998 to 2004 in both civil and criminal areas. Thereafter, she has worked as a lecturer in Andhra Christian College of Law, Guntur and Mahatma Gandhi College, Guntur 2006 to 2012. Madam has joined KIT School of Law in July 2012 and taught constitutional law, administrative law, jurisprudence, human right law. Madam has participated and presented so many research papers in national and international conferences. Ma'am, today we are very glad to have with us, and I am sure that you are going to throw light on our today's theme. Over to you, ma'am.
Thank you. Thank you for an elaborated introduction. Good morning, Mathura ma'am, and all the other dignitaries present over here, and all my fellow colleagues, as in the field of law, they are all my colleagues, and my dear students. Today, on the auspicious day of Constitution Day, I'm very delighted to give this kind of a brief note. I will not say that as a lecture, as it is only in a span of one hour to cover exhaustively is not possible. That's why I'm taking this word brief note about the interpretation of Article 21. Talking about Constitution Day, this is the day we celebrate every year to commemorate the acceptance and adaptation of the Constitution. So on this day, going through the interpretation of Article 21 and finding all the possible things related to the interpretation by the Supreme Court is a very good thing that this college organized this webinar. Generally, I see people only just read the preamble and that's it. But it is a kind of a different way of celebrating Constitution Day. I appreciate the organizers for that. And talking about the topic, so let me share my screen. I have prepared a brief presentation on this. Just a minute. Please allow me to share the screen.
Yes, ma'am. I am made you co-host. You can able.
Thank you. Is my screen visible?
Yes, ma'am.
Okay. So before entering into an elaborated discussion about interpretation of Article 21, let's see the role of Supreme Court and also the power of Supreme Court in interpretation of Article 21. So if we look into the words of Lord Reed in one of his judgments with regards to the power of the Supreme Court in interpreting the Constitution, Lord Reed, he said that there was a time when it was thought almost indecent to suggest that judges make law. They only declare it. Those with a taste of fairy tales seem to think that in some Aladdin cave there is a hidden common law in all its splendor, and that on the judge's appointment there descends on him knowledge of magic words, open sesame. Bad decisions are given when the judge has muddled the password and the wrong door opens, but we do not believe in fairy tales anymore. Precisely, if we look into the essence of this statement given by Lord Reed, that in the initial days, the power of the Supreme Court to interpret the law was not taken into consideration, but they are only just to declare it, whether it is valid law or invalid law, whether it is constitutionally valid or it is ultra vires to the Constitution, only that. So their role was so restricted in those days that very less kind of interpretation, or we can say the judicial activism, we can see in those days. But those are not the days now, because of the evolutions, the social evolutions and other developments, political developments, the Supreme Court, like way back in 1950s itself, started interpreting the Constitution. These words are become very old talking about the power of the Supreme Court, if we look into the words of Alexander Hamilton, who is one of the founders of American Constitution, he said that the interpretation of laws is the proper and peculiar province of the courts. A constitution is in fact and must be regarded by the judges as a fundamental law. It therefore belongs to them to ascertain its meaning as well as the meaning of any particular act proceeding from the legislative body. So these words given by the founder of American Constitution is having more relevance. Even till today, we can see that the role of Supreme Court is not only declaring the law, but as well as interpreting the law. So if we look into the judgments of American courts or the Indian courts with regards to right to life, we can see that much of the development or much of the law was evolved by interpretation, not by the legislature in the way of amendments or enactments, but much of the law is evolved through judicial interpretation. But if we look into our constitution also declared the power of the Supreme Court to decide on the aspects, disputes, and also to uphold the constitution. So this upholding the constitution includes that the gray areas are the areas which are not clear to the people to be cleared by the Supreme Court. So in that way, the Supreme Court started its journey of interpreting Article 21. So way back in 1950 or even before, during the making of our constitution, as our constitution is a modern constitution, it is made only 75 years back. So while drafting our constitution, we have so many examples or so many kind of constitutions already existing those days. And so here we have also enough time to review all such existing provisions related to right to life. Our constitution, while drafting right to life, has taken their sources from American Bill of Rights. As you all know that all fundamental rights are, most of the fundamental rights are from that Bill of Rights. And also we have several other constitutions, and along with we have United Nations Charter, we have UDHR and the other. So here, when the Constituent Assembly was drafting these articles, the fundamental rights, particularly Article 14, 19, 21, which is the core part of the fundamental rights, many debates happened. Many debates took place with regards to how to formulate this right to life in our constitution. So much of the debate was about whether to exactly adopt the expression of American Constitution or to go for a different kind of expression. Because when we are adopting any law from any of the constitutions, we have to consider the socio-political economic conditions of our country. So much of the debate happened with regards to whether we have to adopt the due process law or otherwise the procedure established by law. So with regards to this, many views were given, and also, during the making of Constitution, a team of Constituent Assembly members visited America and also find out about how their constitution is working and what are all the challenges they are facing in those days in implementing the fundamental rights. So this committee who visited US during that time found that American Supreme Court, while implementing right to life, has given divergent views with regards to interpretation of due process law. What is due? So there are contradicting and conflicting opinions were given with regards to the interpretation of what is due process. So in that background, our constitutional framers, they thought, and also like they don't want to give this kind of an uncertain power which is not clear in the constitution to somebody, to the courts as well as to the executive to implement. While implementing, there should not be any kind of vagueness. So in that background, they have adopted the expression whatever we have now in our constitution. So here, if we look into the power of the court in interpreting, you know that the courts are having, Supreme Courts and the Constitution courts are having a right to judicially review administrative action as well as the legislative action. So here, where is the scope for taking the cases summatorily or giving interpretation in the way of judicial activism? That is also one of the important concern which we faced. So if we look into this, the role of judiciary in interpreting Article 21, the judicial activism that they shown, wherever the law is not clear, say for example, the words, if we look into this article, you see no person shall be deprived of his life or personal liberty except according to procedure established by law. Any student or any normal person in their first reading thinks that this is a very simple provision which protects the life or personal liberty, and the state is bound to protect that particular life and liberty, and state shall not interfere into anybody's life or personal liberty except the procedure established by law. But if we keenly observe into this, with regards to the word person, there is no such ambiguity or who is a person and who will get this particular power. That is very clear. But with regards to life and liberty, what is life? What is liberty? That too, the word personal is attached. Unlike the American Constitution, in American Constitution only the word liberty is used, but whereas in Indian Constitution, the word is prefixed with personal liberty. So not all the liberties are covered here, but the personal liberty. So the interpretation of personal liberty is left over to the Supreme Court. And moreover, this procedure established by law, in this expression also, there are several kind of ambiguities. What is exactly the procedure established by law? And here by law, whether it means only in the way of a lex, that is a law, or jus, that is the law. So these kind of interpretation, the scope for interpretation was there in those days. And if we look into what questions we could raise in our mind while understanding Article 21, I have just listed around 5 important, this is not exhaustive list, but these are some of the questions which may rise in your mind while understanding Article 21, also while implementing Article 21. So here, as I said earlier, what is the meaning and scope of the term liberty as used in the Article 21 and Article 19? Because liberty is not only protected under Article 21, it is also protected under 19. 19, which provides different freedoms, have specifically mentioned about the 6 freedoms what we have, and also explained about the reasonable restrictions on such particular freedom. So when anybody's personal liberty is curtailed, whether that should be challenged as a violation of Article 21 or that should be only challenged under Article 19. So these type of questions were raised before the courts. How to find out whether here only 19 is violated or 21 is violated. I'm talking about before the establishment of this golden triangle. Because now the court have come up with this golden triangle where if one right is violated, automatically there is a relationship between the other. So if you can establish your personal liberty is violated, then automatically that will fall under 14, 19, 21 violation. But in the initial days, this question was repeatedly raised in many cases because, you know, why this question has been raised? Because Article 19 and 21, even though both of them are protecting the liberty, but still both the articles are having different limitations, different restrictions. If we look into Article 21, the restriction is only procedure established by law. If there is a procedure established by law, then the legislature, thereby the executive, can violate the life and personal liberty of the person. But whereas in Article 19, the restrictions are clearly mentioned. They are different for different freedoms. 19(1)(a) to 1(g) talks about the freedoms, and 19 clause 2 to clause 6 talks about the restrictions. So the restrictions are different. If we look into 19 clause 2, which talks about the reasonable restrictions on freedom of speech and expression, there are 7 to 8 grounds which are mentioned under 19 clause 2, whereby the government, the legislature can restrict your freedom of speech and expression. But whereas in Article 21, simply if there is a procedure established by law, they can curtail the life and liberty. So 19 is more elaborated with regards to restrictions, with regards to the freedom. So it is a detailed explanation of whatever liberty we discussed under 21. But if we can bring it under 19, then the state is having so many limitations. The state can limit your freedom of speech and expression only when it is affecting the foreign relations, security of the state, or public order, or obscenity, etc., etc. But if it is under 21, then if there is a procedure established by law, that itself is enough. So the state always will claim that it is under 21. So there is a law, they can prohibit, they can violate it. But when the individual, when the person argues, he will argues that it is a violation of 19, right? And only on these grounds only that can be prohibited. So these kind of questions were raised. And in those days, the courts applied several tests for identifying that which violation happened, whether it is 19 violation or 21 violation. Court applied the pith and substance also. Let's see whether, and the other test applied was about the impact and effect. What finally the effect of that particular implementation of such law. So all these were used by the courts to know about which kind of right violation. Still, we can see in many cases while talking about this violation, they will establish that it is a violation under 19 as well as they will also establish under 21. Because establishing violation under Article 21, because of the restrictions, is only one restriction, that is procedure established by law. And here the second pertinent question related to Article 21 is, what are the implications of this phrase procedure established by law? Because we are repeatedly using this word procedure established by law, established by law. What is this? And also here the word law, whether it is talking about a substantive law or it is talking about a procedural, is it a procedural provision or is it a substantive provision? Does this expression mean law in the sense of principles of natural justice, that is just, that is the law in abstract sense? Whether or otherwise it is only a piece of law, that is lex, a law. So this question was also raised in all the cases, starting from A.K. Gopalan onwards. So whether this is a law or the law. A law is a piece of law which only talks about whether procedure is followed strictly, whether that particular legislative body is having power under Schedule 7 or not, Article 246 read with Schedule 7 or not. And in the legislative process, all the process are followed or not. But if we take that expression as just, that is the law, we have to also think about that whether that particular law is fair and just or not. So this expression law, if we take it in the sense of just, that is the law, the abstract sense of law, where the principles of natural justice, fairness and all will come, in that way, that is more broader. But this was narrowly interpreted in the initial stages like A.K. Gopalan, but later in the cases of Maneka Gandhi and other cases after Maneka Gandhi, all the cases, they have taken that the law should be fair and just. Not only that, the procedural things are, it is not about the competency, the legislative competency, whether they do have power or not. It is about whether they made a fair law or not. So, and also the third question about this, has the article conferred on judiciary the power of determination of reasonableness of law is done by due process clause in the US Constitution. So as we earlier discussed about the problem of implementation of due process in American Constitution, which we have seen, what is due? That means what is reasonable. Today, what is reasonable may not be reasonable tomorrow. So this reasonability is a very wider concept, and also it is changeable from time to time because of that. So judiciary is on the responsibility. They have this responsibility of looking into the fairness of the law, how far the law is fair. So not only looking about whether there is a procedure established by law or not, but they do have a responsibility to look into whether that particular law is reasonable or not. And then the fourth question here, we can see what is, in the context of this article, the relationship between the legislature and judiciary. Does the article imply the principles of judicial supremacy over the parliament, over the parliamentary sovereignty? You know, this discussion of separation of powers and the supremacy of, particularly the tussle between the judiciary and legislature. This is a very, very debatable topic, and several debates happened on this. Whether this article is conferring supremacy on the legislature or it is giving supremacy to the judiciary. This is also one important question, because if we look into the expression, that is the procedure, the no person shall be deprived of his personal life or personal liberty except the procedure established by law. So here it is so visible, and the expression is conferring a kind of power on the legislature. The legislature by law can interfere with the life and liberty of the people. But the inherent power of the Supreme Court in interpreting that whether the laws made under such provision are reasonable, fair enough, that power now we see after Maneka Gandhi, whatever the kind of scope for wider interpretation of this, and also a strict scrutiny of all the laws which are violating the life and liberty of the persons, that we can see here. So here in the initial days, all the courts, including that A.K. Gopalan case, if we look into A.K. Gopalan, we can see that several discussions, not at one place, at several places of the judgment, we can see that the procedure established by law was taken by the drafters of the Constitution. Intentionally, they avoided due process clause. Then, in such circumstances, it is so understandable and visible about the intention of the framers of the Constitution. They doesn't want to take due process law. then why to interpret this particular article in that way? So better not to be interpreted that way, but to interpret in this way. Procedure established by law is more narrower than the due process law. So the judges have shown their kind of opinion on this, and a very narrower kind of. So that time, even this question with regards to who is having supremacy, the supremacy is given to the legislature. Legislatures are free to make any law prohibiting the life and liberty of the persons. So this is the one question we can see here. But thanks to the judges of Maneka Gandhi and the later other cases which enabled this particular provision and then opened the gates to many rights which are in part 4 of the constitution, which are not at all like mentioned in the constitution, which are adopted through this particular article, thanks to the bench of Maneka Gandhi. And here, what is the function of judiciary while interpreting this article as a protector of the constitution? What is the role of the Supreme Court in doing this? So these are the pertinent questions which would raise in anybody's mind while reading and understanding the scope of Article 21. So here, as the discussion about how the Supreme Court interpreted all these years, the interpretation of Article 21, as Madam already indicated, some rights which are established under Article 21, like environmental rights, prisoners' rights, and so many rights which were even including the recent judgment of Puttaswamy about the privacy rights. So here, if we move further, just a minute. Yeah. So the journey from A.K. Gopalan to Maneka Gandhi, that was it is A.K. Gopalan decided in 1956 or 56, and then Maneka Gandhi in the year 1978. That journey was very interesting with regards to the interpretation of our life and personal liberty. So when the Supreme Court of US, in the case of Mann versus Illinois, interpreted life as life, not only the physical life we are talking about. The physical life means the physical body or the limbs. If those are affected or if those are violated by the government, then only this right can be used. But that interpretation was gone long back in this case, Mann versus Illinois, where the court have taken a wider interpretation of life. Life includes life with human dignity. The same kind of expression we can see in Maneka Gandhi as well, that Maneka Gandhi court elaborately explained about life, what life includes. And that interpretation was further elaborated in the case of Francis Corelli case, where our Supreme Court has given that elaborated interpretation with specifications, like even what includes. Life includes with the right to life, right to food, right to health, and all other right to shelter, right against arbitrary arrest, and the prisoner's right in the prison. Every detail, every possible detail was given in the case of Francis Corelli case. So here, the Indian courts have took that kind of inspiration and source from the cases like Mann versus Illinois. With regards to the role of Supreme Court, I remember one statement that our courts, Indian courts, are between the English courts and American courts. The English court is having different kind of interpretation and all with regards to life and liberty. And the Supreme Court of America is having a different kind of. So our courts are in between that. So our courts always draw their interpretation from different judgments, particularly with regards to US Supreme Court judgments and sometimes English courts. So here in these cases, particularly Maneka Gandhi and the later cases, including this Francis Corelli case, we can see that the interpretation. And here, these cases, Maneka Gandhi particularly clarified this dilemma between whether the procedure established by law is talking about a law or the law. So the Maneka Gandhi court declared that the law should be fair and just. Not only that there should be a law to prohibit or to violate life and liberty, but that law should be very fair enough, fair and just. And here the procedural, the fairness is not only restricted to substantive fairness, but it extended to procedural fairness. Because in Maneka Gandhi case, when the passport was seized by passport authority, the discussion of whether the violations of natural justice happened or not. Here the court declared Section 10C of Passports Act as constitutional. There is no unconstitutionality. That law was not unfair. That law was fair and it is constitutionally valid. But the authorities, the passport authorities, while implementing Section 10C on Maneka Gandhi, they have violated certain kind of natural justice, which is talking about the procedural fairness. Substantively, the law was very good. Section 10C was declared as constitutional. But how this Section 10C applied on Maneka Gandhi, that procedure, whatever they followed, not providing the basic fair principles of natural justice, that has been held as invalid because she could not get an opportunity to be heard on that ground. So here Maneka Gandhi not only cleared about what is the interpretation of life and personal liberty and what is the interpretation of procedure established by law, but it also talks about whether that fairness, what we are talking about, the fairness of the law, whether it is only substantial or procedural fairness. So this judgment has opened the gates to so many rights. So the later courts could open or establish many other rights, like what we see now, even including the cases recently decided with regards to right to life. And here I want to also highlight some of the sources from where the judiciary taken the kind of interpretation. So primarily, basically, if we look into including the judgment of Maneka Gandhi, where Justice Bhagwati and others interpreted the life and personal liberty, there is a lot of impact of international conventions and treaties, which we are the parties to such particular conventions. So many conventions, particularly UDHR, Universal Declaration of Human Rights, and the other two covenants, ICCPR and ICSCR, including the protocols to UDHR, all of them we have signed. So when during the protocol of this UDHR in the year 2008, the difference between civil and political rights, economic and cultural rights have gone. You know, we also discussed this. Part 3 rights and Part 4 rights. Part 3 rights are enforceable. Part 4 rights are not enforceable. We clearly drawn a difference between these rights and these rights. So that happened there also at the international level. Civil and political rights have been taken very seriously. Economic, cultural rights have been taken, not that much enforceable. But after this protocol 2008, there's no such difference between these rights. So the same exact kind of interpretation we can see in Maneka Gandhi as well, way back in 1978 itself. Even though the court has not specifically declared that all the directive principles are enforceable, but they have shown a way, a path to enforce directive principles under Article 21. So slowly, all the rights in Part 4 of the Constitution also enforced through Article 21. So there is a lot of influence of all these conventions, international conventions. See, if you look into Vishaka case, when it was decided, we do not have any legislation addressing the sexual harassment at workplace. But by that time, Vishaka judgment time, we have already signed SEDA, the Convention to Eliminate All Discriminations on Women. We already signed it. But we are yet to make a law to implement such convention. So that time, the court drawn its source from the convention, SEDA, and then declared that these are all the guidelines to be followed in all the working places. So in that way, you see any case where life and liberty has been interpreted and drawn some or other right into Article 21, you can see the discussion of international conventions, either UDHR or the other conventions and treaties which we signed, including the environmental conventions. So you see all the environmental cases where right to have a healthy environment has been declared as a right under Article 21. They discussed all about those conventions, treaties, which we signed and ratified. So it is our obligation under international law to implement them in the domestic laws. So accordingly, if the legislatures are taking some time to make such particular laws, the court, the Supreme Court, as the protector of the Constitution, they are having that responsibility to bring in such international norms into our system before the legislature makes any law. So that happened in this particular case, that is sexual harassment at workplace. And we have so many examples, so many judgments reflects our international conventions. And also there is a lot of impact of natural law philosophy. You see all these interpretations under Article 14, 19, 21. Judges like Bhagavati, Krishna Iyer and others, they have a lot of impact of natural law philosophy. Even though our system is a combination of civil law and common law, we do give more importance to black and white letters. We have more positive kind of attitude, but still, while interpreting the Constitution, all the judges have taken the source as this natural law philosophy. And we can see the impact of several judgments of different countries' courts, particularly, as I said, the American courts, may it be with regards to interpretation of Article 21, or maybe it is with regards to PILs and other concepts. We adopted it from the American courts. And also, as the Constitution was said as a living Constitution that should transform into different levels because of the social change, social transformation, and also economical transformation, political transformation. Because of that, also several courts in all these years, like may it be with regards to the judgment in the case of Olga Tellis. Olga Tellis case is an excellent example which shows that these the fundamental rights particularly should be interpreted in such a way which can accommodate all the interest of today's and also address all the problems of today's context. So this evolution, but the social transformation, economical and political transformation is also leads to this kind of interpretation. So because of all these and because of the activism, the judicial activism. Activism, we can see that abolishing bonded labor, and also not only abolition of bonded labor is mentioned in the Constitution itself in the fundamental rights. But after abolition, what will happen to such bonded labor? So to provide them with some kind of alternative jobs, or to facilitate them somewhere, that kind of duty was also recognized under Article 21 with those cases, PUCL versus Union of India, and other cases where these all problems were addressed. So here, you know that fundamental rights are, most of the fundamental rights are negative in nature. Negative rights. They are negative rights, as in they prohibit the state not to interfere with the freedoms or rights of the people. But some are having positive rights as well. Like, for example, Article 14. Article 14 is a combination of a negative and a positive right. That's why we do have two expressions: equality before law and equal protection of laws. That is exactly as the expression of UDHR, where both are mentioned. Not unlike the American Constitution. American Constitution only talks about equal protection of laws. So here we can see there is a prohibition on the state not to discriminate, and also there is a responsibility on the state that they should see that nobody will be discriminated in the society, and also provide some kind of affirmative action for such disadvantaged groups. So a positive right is a right where the government have to do something to enforce the fundamental right. Whereas a negative right is a right where the government is stopped or government is prohibited to do something. So this combination of positivity and negativity brought into Article 21. So all these kind of providing rehabilitation to bonded laborers after releasing the bonded laborers, and also providing an alternative shelter to the pavement dwellers in the case of Olga Delhis. All these, through interpretation of Article 21, Supreme Court could make such a kind of responsibility on the government. You know, even if you look into Ratlam municipality case, this Ratlam municipality case, particularly the opinion of Justice Krishnaiyer in this case, is providing a duty on the government. In that case, municipal corporation, they argued that they only have the power, they do not have the duty to maintain a proper drainage system and also to protect the properties of the people during the flood. So the court interpreted that the power is always coupled with duty. No power is absolute power. All the power, you have the power to tax people. At the same time, you have a duty to maintain all these. So such kind of interpretations bring this kind of positive right characters to a negative right. This is actually a negative right, because the expression is no person shall be deprived of his life and personal liberty except the procedure established by law. The Constitution only said don't interfere with their life and liberty. If you interfere, then it is a violation of law. But nowhere it said that you have to protect them also. That positivity has been brought by the interpretation of the Supreme Court. So the way they interpreted that, the title of this particular webinar is exactly suits the way how Supreme Court articulated and interpreted this particular Article 21. So by these words, I conclude my presentation about interpretation of Article 21. If you have any questions, then I'm here to address all your questions. Thank you.
Any questions by the students?
Thank you so much, ma'am. Thanks for your words of wisdom. I would like to ask student if you have any questions related to this, kindly ask. You can raise your hand uh, so that we can unmute you and you can ask question to ma'am. This digital platform now open for question answer session. Any question from student side? Any questions? If ma'am permit me so that I can start this question answer session as a
Sure.
genuine viewer and audience of your this national webinar, I have a question in my mind. Ma'am, you have explained it very well, but just want to ask that this right to life, actually, yes, judicial interpretation is always there. It is expanded and we can talk hours and hours on this. But I just want to ask you that how it is difficult for judiciary to interpret Article 21, because ma'am, you also know that this Article 21 is having a very huge scope. Its ambit is very huge. So I just need to ask you that how difficult for judiciary to interpret Article 21, because there might be differences, there might be public outcries sometimes. So how difficult for judiciary, because they are actually going beyond their powers and they are giving a different judgment, landmark judgment. So how difficult for them to interpret Article 20?
Yeah. In the background of socio-economic problems, what we have, this problem was faced by the judiciary from day one of our constitution.
Yes.
May it be with regards to accommodating the land prohibition acts.
Yes.
And the motive of the government to provide economic justice through land sealing. So every time the judiciary was in that kind of situation where they have to balance between the power as well as
Yes.
the welfare of the people.
Absolutely
So
correct.
particularly in case of Article 21, as I already told you with regards to the intention of the constitution framers to intentionally exclude due process and intentionally adding this procedure established by law. This argument was taken by so many people in so many cases, arguments. And is it not a kind of what we
Yes,
can
yes.
say, that the Constituent Assembly and the framers of the Constitution, when they intentionally excluded, bringing that back from the back door, whether it is how far it is advisable and how far it is good.
Yes.
That
Yes.
kind of discussion also happened starting from A.K. Gopalan onwards to all the cases. And also this judicial activism, whatever the judges, they are doing it for the benefit of the people. Okay, but what about the government? How to balance? Say, for example, when the food security and right to food has been declared as a fundamental right, not only as a fundamental right, see, declaring a right as a fundamental right is so simple. But if we look into the implementation of that, the burden on the government to implement, not as a negative right implementation, okay, we will not stop anybody from taking food. But what about providing food?
Yes.
Providing food, a positive kind of right, which is conferring on the government forcibly, right to health. During COVID days, non-availability of oxygen cylinders was challenged in many courts as violation of Article 21. But how far Article 21 is imposing a kind of positive right on the government? It is saying that no person shall be deprived. They are not taking away anybody's oxygen. No? So this kind of positivity within this particular right created by the judiciary in many cases has burdened the government. We have less resources and the court is repeatedly saying to provide everything free. Education to anyhow free, health also free, everything is free. Then how to run the nation? So that is also an important way. But many judges successfully maintain this balance. But some decided on one way, not looking into the kind of problems faced by the government, but they have maintained it. Particularly like the judges like Krishna here particularly. They look into Ratna municipality case and other cases. There they have even thought of about the government also. See, in some cases where the right to broadcast was challenged as violation of 19, where the broadcasting rights were restricted. In that case, the advocates from the side of government clearly argued that we do not have resources. The broadcasting ability, that technicality is very less. If we allow everyone, then how can we use that? Resources are less and
Yes.
the people are more. So the courts do consider such kind of arguments in their judgments. That balance we can find out in few cases that is maintained.
Yes, absolutely correct, ma'am, and very well explained. Actually, you said it correctly. The balance should be maintained, and judiciary knows their power. They knows that it should not exceed, and they should within that ambit only they need to deliver such kind of judgment which will help our society and help in social transition in real sense. Thanks a lot, ma'am. Any other student want to ask question? Yes, Mohit is asking, he is having question. Ma'am, I'm just reading out the question is.
Yes, I
uh,
read the question.
Parliament, yes, yes. Can Parliament change the judgment of Supreme Court?
Very good question, Mohit. See, the Parliament is having power to change the judgments. That happened in the case of Indra Sahani judgment, when the court declared that few of the principles declared by the court in that case, Indra Sahani, I will just tell you. It talks about that with regards to carry forward rule, that there should not be a carry forward. It is only 3 years they can carry forward the particular posts under Article 16 if they are not filled up. And that will be carried to 3 years. And if it exceeds 50%, then whichever is earlier, they have to follow. So immediately after the judgment of Indra Sahani, the Parliament by an amendment, they amended Article 16 and then said that this particular posts which are unfilled under the reservation category will not be added to general category after 3 years, but they are kept aside and have a specific notification for that. So the Parliament do have the power to change the judgment. That happened in many instances. Whenever the judgment is there, that 9 judge bench or 7 judge bench, the Parliament makes an amendment and they make it changed in the amendment. Okay.
Yes, absolutely correct, ma'am. Any other student want to ask? Ma'am, our principal ma'am is here. Over to you, ma'am. Ma'am, unmute yourself. Ma'am, you unmute yourself.
Okay, that is it. Madam, you have very well explained about Article 21. It was a very interesting lecture today. And from initially you have pointed out many things from the role of judiciary where the law is not clear. We have judicial activism over there. With the explanation of the cases, that is A.K. Gopalan case, Maneka Gandhi, right to fair justice. So how the state liable to protect life and liberty? You have also elaborated the problem from your own angle, that which posed in Article 21 by that 5 question. That was very fantastic, madam. And also you have explained about the due process and reasonableness of law in US Constitution, supremacy of the Constitution on judiciary and all. And also one more case law, Vishaka case laws that you have explained, which was related to right against the sexual harassment at workplace. And for that, madam, actually Supreme Court with a very beautiful line they have quoted that the meaning and content of the fundamental rights which is guaranteed in the Constitution of India are of the sufficient amplitude to compass all the facets of the gender equality, including the prevention of sexual harassment or abuse. So many things through the case laws, madam, you have highlighted and guided to our students. And I can also explain one more case law that was related to Article 21 only, that is Bandhu Mukti Morcha versus Union of India, which is a very characterized as a heart of the fundamental rights. So many cases are there which we can definitely share, and we can definitely talks on that. But due to the time, we will try to wind up with the session. So I may ask Amar sir to go with the other process. Thank you. Thank you, madam. Thank you.
Thank you so much, ma'am. Now I would request our BLS CR, Kushi Agarwal, kindly read out preamble of our Constitution of India.
We, the people of India, having solemnly resolved to constitute India into a sovereign, socialist, secular, democratic republic, and to secure all its justice, social, economic, and political, liberty of thought, expression, belief, faith, and worship, equality of status and of opportunity, and to promote among them all fraternity, assuring the dignity of the individual and the unity and integrity of the nation. In our Constituent Assembly, this 26th day of November 1949, do hereby adopt, enact, and give to ourselves this Constitution.
Thank you so much, Kushi. Now, a very formal ceremony is a vote of thanks. I, Assistant Professor Amar Salve, feeling extremely honored while extending a formal vote of thanks on behalf of Hindi Vidya Prachar Samiti's College of Law at this online national webinar on the occasion of Constitution Day 2022. Firstly, I take the opportunity to thank our very supporting management. Thank you for their staunch support for every event, starting with Dr. Rajendra Singh sir, President of Hindi Vidya Prachar Samiti, Dr. Usha Mukundan Madam, Director of Hindi Vidya Prachar Samiti. I would like to express my sincere and hearty thanks to our Honorable Principal Madam, Dr. Mrs. Madhura Karamkar, for her timely instructions and kind support for the success of this program. Thank you, Madam. I want to extend my heartfelt gratitude to today's guest speaker, Dr. Kaivalya Garikapati Madam, Associate Professor, HOD Department of Constitution, KIT School of Law, KIT University, Bhubaneswar. Thanks, ma'am, for delivering a very insightful lecture on this occasion. I am thankful to all the teaching, non-teaching staff for their kind cooperation. I am also thankful to our technical team for their flawless technical assistance. Last but not the least, all dear students present here. Thanks once again. I would like to request everyone kindly fill feedback link which we have already pasted in the chat box. Once again, a very happy Constitution Day to everyone. Thank you so much.
Just one thing, sir, I would like to announce for the students. This thing is, you have to fill up the feedback form, and also another thing is that in the feedback form we have kept certain questions in relation to today's webinar, as we are considering this webinars for evaluation purpose as well. Therefore, if you complete this particular process, only then you will be getting your certificates, and once you receive the certificates, that will be considered as your evaluation purpose as well. Okay, so please fill up the feedback form accordingly.
Thank you so much, Ritupana ma'am. Principal ma'am, with your permission, we can end up today's. Thank you, ma'am. Thank you once again, Kaivalya ma'am. Thanks a lot.
Thank you all.
Thank you, Kavala madam. Thank you so much.
Thank you.